Well, we have reached the appointed hour and we have a quorum. Late Friday evening, the administration gave us an English version of the paper. Members may not have a chance to read it. And then the Secretariat is able to give us the Chinese version this morning. And the paper number is CB-2-106/12-13-01. I believe members may not have time to read the Chinese and English version of the paper because the paper came to us very late in the evening on Friday. I will invite the administration to take us through the paper first, and then, well, this is the only new paper, and we have other papers which are old ones. As for the representatives coming before us, they are Ms. Elizabeth Tai, Ms. Margaret Lee, Mr. Richard Wong, Mr. Michael Lynch, Mr. Dr. Chen Man Wai, and Ms. Bonnie Wong. Thank you for coming. And I hope that we can deal with some of the issues right away. Ms. Tai, would you take us through paper CB-106? Thank you, Madam Chairman, and thank you, members. And I apologize for not being able to give you the paper at the first instance, though we tried our best to give the paper to you as soon as possible. This is to further may explain the need for taking over the WK waterfront promenade by the WKCD, and we've also provided the timetable for the subsidiary legislation. Advanced work will begin in 2013 at different places, including the waterfront promenade. There will be site investigation and other advanced works. And then there's a need to construct permanent facilities in phases to protect public safety. Because of the advanced works, the promenade will be closed gradually, and that is because of public interest. If we need to set subsidiary legislation before taking over the waterfront promenade, that would delay the works. The waterfront promenade will soon be closed by a temporary administrative rule or set of rules. Managing this promenade is appropriate. As we explained, these rules are based on Cap 13BC and with modification. This is to provide a better environment to the public. Members may be concerned that the WKCD's development is at a very critical stage. There is a need to draw up the development plan. There is a need to design the culture and art facilities, establish its governing regime. At a joint meeting of this council, members reminded us that we had to provide the software and hardware in tandem. The WKCD, therefore, has tried to make good use of the site under its management, conduct a number of culture and art activities to attract people to the WKCD and bring art and culture to the people. We understand members' concerns, and we know the importance of the subsidiary legislation. Now, if you may refer to Annex 2, the promenade is part of the park. And if we are to build the park, we really need to demolish the promenade and then provide a better and a newer design. And if we are to set subsidiary legislation for a promenade which is to be closed very soon, will that be a good use of resources? The WKCD will also embark on the design of the future park in late 2012. The management of the park is closely related to the design of the park. The authority wants to consider the whole arrangement comprehensively, and the bylaw being prepared will be modeled against good practices in other parts of the world, and we want to get the best at the bylaws. Now, part of the park will be open in late 2014. The authority will prepare the bylaw next year and consult members. We know we need the endorsement of this council for the bylaws. Other members have also asked questions concerning management, so I will speak on that. For the effective management of the STT and also the enforcement of the house rules, a professional management company has been commissioned. In the past, the company provided security service to the LCSD. The authority has also reserved adequate resources and manpower to look after the area. The manpower will be even bigger than that of the LCSD. There will be full-time on-site staff. In the past, the LCD provided cleansing and security, but the manpower to be provided by the authority will be even more than those provided by the LCSD. As for events that will attract a lot of people and that will attract large crowds, the WKCD will require organizers to comply with the terms and conditions of the STT and other license agreements. They will also work with the FSD, the police, the EPD, the transport department, to make sure that the public safety is upheld, and there will also be crowd, noise, and traffic control. Whether the promenade is a pleasure ground managed by the LCSD or under the WKCD, it is regulated in the same manner as far as large-scale events are concerned. The WKCD has to take over the promenade in order to organize various activities, for example, the Hong Kong Wine and Dine Festival 2012 and Clockenflap. The footprint of these activities will cover the promenade as well as the STT area obtained earlier. Now, if the participants have to comply with two different sets of rules, it will be very confusing, and it will also be difficult to manage. We believe that the WKCD is capable, and there's a real need for the WKCDA to take over the promenade. We hope that the project will go ahead as soon as possible. Well, even if you have spoken with eloquence and with emotion, you have not convinced us. I'd like to remind members that we have this Annex 2A, which is the promenade. It is rather small. Now, this is the Oasis, Norman Foster's Oasis. It's a pity that you don't have the color photocopy. Now here, there is a hashed area all the way around here, over here. This is a driveway. So the size of the area is not big. Now the lower one is the inclusion of other cultural facilities and also residential development. Now you have the minutes of the District Council and also the pleasure ground, the pleasure grounds regulation side by side, the temporary rules, and members can compare that. Mr. James Ho, I want to ask this question. Has the paper been cleared by the Policy Secretary? Yes, indeed. Well, I'm really angry. Now, if you look at paragraph 12, I don't know whether you understand it or not. Now, last week we talked to you. I don't know whether you understand us. Now, this is a change from a statutory regulation to an administrative regulation. Now, you say the last-minute changes to the management of promenade would cause major disruption to these two events. I want to ask you, do you think the Legislative Council has to approve your proposal? Do you think we are just a rubber stamp? Your idea is very simple. You don't want to set the bylaws in order to save resources, because if you set bylaws, because the place is to be demolished, how much resources do you need to set the bylaws? Why can't you do it earlier? Is it because of the HAB it is sitting on his hands and just take the LegCo as a rubber stamp? So who should take the responsibility? I find it strange. You say that the place is to be demolished, therefore there is no need for the bylaw, and a lot of resources are required for bylaw. I don't know how much resources you need for the bylaws. Do you think you need a lot of people, a lot of lawyers to draw up the bylaws? I don't think you need so much resources. And it's even ridiculous that you can gather, without the bylaws, you can gather experience in the future. You can draft even better bylaws. Now, for several years, you don't have any bylaws, and then you say that you can gather experience and draft even better bylaws. You don't have it. You don't even have the bylaws. That's really illogical. Now, to promote, to ensure that is there should be regulation according to the bylaw, but you turn the bylaw into administrative arrangement. There is a big difference between administrative arrangement and the bylaws. To be consistent, the place should be managed by bylaws all the time. It should be managed by the bylaws all the time. And we did not expect that the matter can be dealt with by administrative means. And all the consequences should be borne by the administration, as said by, to borrow a word from the Chinese Ministry of Foreign Affairs.
You should have asked the West Kowloon Authority to handle this early in the planning stages. You should be aware that the bylaws are inadequate. Chairman, they have never answered our question, why do they have to change from bylaws to not bylaws and then revert back to bylaws? Why is that the best legal mode? They have not responded. They have not responded to the DOJ. So I don't know how to proceed, Chairman. The question is, you've created a mess. Well, the Secretary should come to respond. Does he think that that is the best way forward? So the whole authority, is it their view that the LegCo is a rubber stamp, that it will be endorsed without question? That's the whole attitude of the administration. You've never considered that we would reject this proposal, Mr. James Toh? There are no responses to your questions, so perhaps Ms. Dai can respond. If we suggest abolishing this bylaw, then what will the outcome be? How will that impact on West Kowloon Authority, and how will that affect the activities in November? Or to put the question in another way, if we use the existing LCSD bylaws, what would the outcome be? Well, I'd like a specific response. What kind of bylaws would obstruct the conducting of these events? Is it that LCSD doesn't allow the sale of alcohol, but the other regulations allow for consumption of alcohol? But I remember Wine and Dine last year, they were serving alcohol. Why is it possible last year? So could you give us a specific law? Tell us which laws are incompatible with the activity. I want a specific response, quoting specific laws. There are a series of questions. I'll try to respond one by one. First of all, we respect the LegCo. Mr. Toh can rest assured. I want to emphasize again, we have not assumed LegCo will endorse it without question. I want to clarify that first. When we examine the issue, why do we have two modes? We had explained just now. Legally, Mr. Toh, you expounded on the situation, the legal framework. But legally, the West Kowloon Authority, they have a short-term tenancy role. They can exercise their role through the short-term tenancy, and there are other laws that manage this relationship. They might not be a bylaw. I'm not saying bylaws are unimportant, but this is part of our consideration. That is, short-term tenancies have their own regulatory framework, and we see that within LCSD, when they manage the area, they will issue warnings if there are any breaches of the rules, and if the visitor continues to engage in the behavior, they will be issued a warning and we ask to leave the premises, and they will also seek police assistance. So within West Kowloon and LCSD, there isn't a large difference in managing of playgrounds and open areas. So as I said just now, in order to enforce the rules in an efficient manner, we have sufficient manpower, because, Chairman, could they respond? Did West Kowloon ask them not to pursue the drafting of bylaws? Is it the West Kowloon said they don't want to expend extra resources, they don't want their in-house counsel to undertake this work? Was it you or West Kowloon? Did you instruct them to use the administrative rules?
Sorry. Dai 小姐,
Ms. Dai, Mr. Toh asked who decided on pursuing the abolition of bylaws, promenade bylaws, and you don't have to respond to the rest, just respond to Mr. Toh's question. Was it the Policy Bureau decision? Did you consult DOJ? Did you consult West Kowloon Authority? A simple response is sufficient. We did not make a request because the bylaws need to set aside that piece of land for the work. We had not asked West Kowloon Authority whether they should undertake this. We're looking ahead. So who made that decision? Was it a LCSD proposal, or was it a Policy Bureau proposal, or was it a DOJ proposal? The LCSD we're not asking for reasons, we're asking which department or bureau made a proposal to undertake this proposed method. We had asked, did DOJ provide you with opinion? So could you consult your DOJ colleagues, because legislators feel that you are not following procedure. We don't have an opinion from DOJ. The document has reviewed our proposal. Well, I don't see. So are you saying DOJ is endorsing the whole document? They have reviewed our document. They had provided opinion. Well, I think we need to ask the DOJ. Do they agree with having administrative rules replacing a bylaw? So the new Chief Justice or the new DOJ will have to respond, and the Secretary of Justice will have to respond. So West Kowloon Authority, I think there's no problem with them. They are not a legislative department. They deal with administrative and they manage activities. Second legislator, Mr. Zhong Xugan, I'd like to ask, in paragraph 11, there are 5 events. If we use the old regulations, is it not manageable under the old regulations? And out of the 5 activities, which is in breach of existing regulations? And this breach, can it be handled by way of administrative measures? Can we bypass the obstacles? Are there temporary measures? Ms. Dai, do you need to defer to the authority? Well, I'll respond, they can supplement. Well, I think perhaps West Kowloon could respond in greater detail regarding the specifics of the events, but there is a basic principle. First of all, we understand the importance of bylaws. Now, if this area is still managed by LCSD as a playground, then West Kowloon will have difficulty in its engineering works. This is a basic consideration because the engineering is on a tight time frame. If it's a playground, the land use should be limited to playground use. So if West Kowloon were to board it up as a construction site, then it's not compatible with it being a playground. And initially, the promenade was just a short-term facility. Before the construction began, it was managed by the LCSD. And now we're embarking on the construction works in 2013. And West Kowloon needs to use the West Kowloon laws and regulations to manage the site. So this is the basic reason why we understand the event is important, but in principle, why do we have to manage it separately? It's because the West Kowloon works will have difficulty in embarking on construction work, and this will commence in the beginning of 2013. And in addition, the West Kowloon Authority, they have their own mode, they have a relationship with the event organizers, they have their own priorities, and it might not align with LCSD, so perhaps I can defer to Mr. Lynch. Well, Ms. Dai, I need to challenge your response. First of all, the information you've provided, LCS 19, it had never mentioned construction issues. In your previous meeting, you had never mentioned construction issues. Why are you telling us today that construction work can only commence when the bylaws are abolished? When we had works in Victoria Park, there were no similar arrangements. You cannot make up an excuse. You had made a mistake previously. I think we should now seek a solution. You made an omission. You did not use bylaws to take over other bylaws. That's first. Second, you have now signed a contract with an event organizer. Mr. James Ho and Mr. Zhong Xugan are trying to assist you. They're asking if we use the old bylaws to host the event, how would that be inappropriate? So you cannot use construction works as an excuse. Ms. Dai, Mr. Zhong Shugan, I agree with the chairman. Victoria Park is now building a swimming pool in Quarry Bay, also undertook some works, and there were no conflicts. If you want to facilitate the works, well, then you just need to draft new bylaws that could solve the legislature's query. We're trying to help you. What contradictions are you running into right now? Well, you need to bring it to the forefront and allow LegCo to help you bypass that. And if not, how can we host these events? I think that should be the way forward. You have 5 events running all the way to 2nd of June 2013. You are applying the LCSD bylaws. Then you can scrap these bylaws on 2nd of June 2013. Mr. James Toll, I think I'm catching on to the enigma. Well, this is a piece of government land, and they are renting it to West Kowloon Authority for construction works. Now, they're renting it, so it's not a playground. It cannot be a playground for construction works to commence. Well, there's another option. You can just grant the land to West Kowloon. Once you grant it to West Kowloon, then you can scrap the bylaw, and they can commence works as owners and draft their own bylaws. I can understand your dilemma. It's not the West Kowloon's land. They cannot draft bylaws. So the administration should be generous. Just grant the land to West Kowloon. That is, the lands department should vest the land in West Kowloon. So the West Kowloon can come up with 2 sets of laws, abolish the playground regulations bylaws, and West Kowloon board at the same day, be it a construction site or whatever, they can draft a new set of bylaws. So legally, you can have a seamless integration of these bylaws. Have you considered this option? Why don't you do that? That's what I have in mind. But what you're proposing is infeasible. They cannot draft bylaws on premises that they are renting. It might be possible. To give an example, West Kowloon could rent a warehouse in Tuen Mun and call it West Kowloon Tuen Mun branch or subsidiary, and they can relocate M+ over there temporarily, and you would have to draft bylaws. So you can apply it on the rented premises. If there's no difficulty, then I'd rather you have bylaws to regulate this construction site rather than your cumbersome proposal. What is it? Is it a legal obstacle? If West Kowloon Authority laws are wide enough in scope, they can regulate non-owner land. I think that's too late. The first event is 1st of November 2012. We're on the 29th of October now. The West Kowloon bylaw, is it negative vetting or positive vetting? Well, once the board endorses it, and if it's not too different from the administrative rules, they can just submit it to LegCo. They can't meet the Gazette deadline. So we're coming back to Zhong Shugan's proposal. Last year they did a carnival, and that was run under the playground bylaws. The only option we have is to use LCSD regulations.
The 2 members asked the HAB, what are the problems of using the old regulation? Mr. Lynch will answer the question.
Committee, I think it's really important to understand the distinction between the LCSD portion of the land and the portion of the land given to us under the STT. There was no requirement under the STT from the Lands Department for us to establish bylaws for the STT in the short term. Clearly, the idea that the integration of the two pieces of land was absolutely important and critical to our development of the site. We have discussed it with the other committees of LegCo many times over the course of the last year, that we were embarking on site investigation works, development of the park. We have provided the timetables of all of the construction works. We have provided all of the anticipated short-term activities that we were going to put on the site over the course of the year, primarily for the benefit of the public, and that and our best view was that you needed to manage those in an integrated way. We have no objections to the absolute resolution in line with Mr. Toe's comments that once we get a land grant, which we do not have yet, we have one short-term tenancy over the substantial proportion of the land. We have a development plan that is presently in its final stages of resolution with the Town Planning Board, and that we would hope by the end of the year to be able to begin the land grant process, which envisages, as it's well understood by LegCo and by all of the other parties, that West Kowloon will become, in line with, I think, Mr. Toe's suggestion, that the whole piece of the land becomes West Kowloon, and we would then set in place a set of bylaws and whatever other administrative arrangements are necessary to be able to make sure that we are both complying with LegCo's wishes, we are complying with the law of Hong Kong, and that we're doing it in the most practical way that encompasses a quite difficult combination of activities. We want to maintain public access to the site as much as possible. We want to be able to undertake events that are both ours in terms of cultural activities for the public. We want to be able to accommodate events like the Wine and Dine Festival, which we have a contract with the Hong Kong Tourism Board with, to be able to use both part of the promenade site and part of the STT site. And in regard to the other events, clearly they cross over. It's a very arbitrary piece of land, the promenade site, cut out from the other site. We've got maps which we can provide you of the difficulties in administering the three or the four different activities that we propose to do, the public activities, which show the difficulty of having one set of administrative rules, one set of bylaws for part of the site and one for the rest of the site. And clearly, I guess, I understand your concerns, but I think it's really important that until we get a land grant, we are really in a difficult situation. We believed, and the reason for moving forward in the way that we proposed was to that there be one person in control of the site, in control of the management of the site, in control of the risk management of the site, and in control of being able to deal with the different demands of doing events, maintaining public access, while at the same time, which I think everyone recognises, that we had promised to deliver part of the park to the public by the end of 2014. And so the issue of site investigation, early construction works, establishment of the nursery and a range of those other things become absolutely pivotal to being able to deliver the park by that 2014 date. And so I guess that's where West Kowloon sits in regard to the thing. And I see no difficulties once the land grant process has gone through, that we would then be able to establish as quickly as you would like the sets of bylaws that we need to to manage the whole site, but not this idea that you would have separate sets of bylaws for the promenade, for the children's playground or for the STC site.
主席，我想問下我哋法律顧問有冇睇過西九？
I want to ask our legal advisor whether the legal she has studied the bylaw requirement, and whether the bylaw can only be set for the land that has been granted and not the land that is hired by the WKCDA. Now, according to Section 37 of the WKCDA Ordinance, the WKCDA is authorized to establish bylaws. The authority can set bylaws for the following purpose or purposes, A and B. Establish bylaws for arts, culture, and related facilities and ancillary facilities for the management operation of such facilities. B, bylaws for any premises, buildings, structures in the area granted to the WKCD and to regulate the behavior in such premises. I want to ask you, according to your understanding, can they set bylaws for the places hired by them? According to Section 37, the bylaw, the WKCD, according to the provision of the law, it is within the granted area and area outside the granted area. The bylaw can apply to all these places. So that means the bylaw can be applicable to hired places. Mr. Ho, I hope you understand that the next activity is on the 1st to the 4th of November. I just want to clarify the concept. If the WKCD says that if the land is not granted to them, if the land is just hired or let to them, then the WKCD cannot make any bylaw on the hired land. But that is not the case. In fact, according to the answer, they know that they can do it on hired land, but they think that may not be appropriate to establish bylaws on hired land. But the understanding, but I think they can do so. And it is also appropriate, though the WKCDA may not think that is appropriate. Now, concerning the comparison between the two sets of rules, is there anything that is standing in the way of the activities as far as the regulation is concerned? Last year you also had the Wine and Dine Festival. So the regulation, the pleasure grounds regulation, is not standing in the way of the activity. So can you tell us what activity is impeded by the pleasure grounds regulation? All right, and I will ask the Bureau to answer the question because the Bureau knows thoroughly the pleasure grounds regulation. Now, if the pleasure grounds regulation is applied, is there any problem? And why is there a problem?
Matter of cultural policy. It is a matter of legislative
I have nothing to do with cultural policy.
It is not that much a matter of operation on the site, but we are talking about the difference between the two sets of rules. So I need the civil servant to give me a direct answer. Thank you.
The LCSD. If I may answer the question. In dealing with non-designated activities such as Cook and Flock and the Wine and Dine Festival, we require the applicant to make an application to us, and then we vet the contents of the activity and see whether the activity is worth supporting, and if you find it acceptable. And then we also need to consult other government departments concerning the crowd management, fire safety, so on and so forth. Now, having obtained the views, then we will inform the applicant our requirements, set out the conditions, and the applicant will have to obtain the relevant licenses or permits. Therefore, if you have to go through the bylaw phases, we will not be able to meet the timetable. And the WKCD has been talking to the applicants. Concerning the conditions of use. And also the conditions of the LCD, they are different, and also the fee charging are different. So, Ms. Lee, are you telling me that we do not approve this, then you cannot organize the event? So you think that we are a rubber stamp? Have you promised that the regulation will be endorsed? Now, before the regulation is withdrawn or repealed, the LCSD can tell people that the applicant can assume that the regulation will be repealed. If it is written in a contract, then you just treat it as a rubber stamp. Well, you should have told the applicant that he or she has to comply with the two set rules. Now, Mr. Wu Chi-wai, he will have the first round, and then I'll give the floor to Mr. Chung first, and then they will answer the question at one go. I think they've made it a mess, and they can't fix it. Mr. Wu, is there a river of no return, so to speak? The only thing we can do is to delete this. Now, if it is to be organized by the LCSD, they will have to do a 2-month consultation. I just want to confirm this. Last time, we were told that on the 6th of July, the site was deleted. And if we do not accept the deletion, it will remain on the schedule. And the LCSD says that there is a very complicated set of administrative arrangement. But if you follow the arrangement of the Nanlian Yuanqi, then you just can give the management to the authority. No, then the LCD will be in breach of the law. If we repeal this regulation, then it will be under the management of the LCSD. Then the LCSD will have to spend 2 months to consult the departments, according to Ms. Wong. But if the management is given over to the WKCD, then you don't need to rely on the LCSD. You just assign the management to the WKCD, and then the WKCD will just follow the regulation.
So even if you assign it to the West Kowloon Authority, they still have to deal with the licensing. So you cannot say that under your own regulations certain work is exempted. But under LCSD, I think the director has some discretionary powers. If it's too urgent, as the chairman says, they have to do consultation. So whether it's the secretary or chief secretary, you can convene a meeting. If there's no objection, then you can respond to that. I think you have some discretionary powers. You are forfeiting the law, and if you just delegate, you might not be able to regulate the process. Mr. Leong, I'd like legal counsel to assist us clarify the situation. On 6th of July, it was gazetted. Then LegCo was in recess. It was gazetted, and there were any LegCo bill committees in effect. So have they deleted the pleasure grounds from the bylaws? I want to clarify that, because if we were to repeal that now, up till the last minute, is it considered deleted from the list? I'd like to clarify that. In our scrutiny of the bylaws, the repealing takes effect on the date of Gazette, that is on 6th of July. So it has already been deleted. So the answer is yes. Then I'd like to follow up. That being the case, before 4th of November, we cannot take this de facto situation and we cannot apply negative vetting and repeal it. So how will that affect the wine and dine event? There shouldn't be a problem with the wine and dine event. The next event, Renaissance 2012, will be affected. So I'm not sure if Mr. Wu Jiwai's proposal is effective, but if you're referring to Wine and Dine Festival 2012, it should not be affected. I mentioned on the last occasion, and I agree with the chairman and other members, that they have not responded to our questions. That is, in dealing with the promenade. The Policy Bureau, or LCSD, have they considered the panel's suggestion? There is a regulatory vacuum. Now, if I don't see their response to our subcommittee's query, this is not ideal. Of course, the negative vetting, we have to accept the outcomes, but I'm considering, of course, I don't want to impede the event, Wine and Dine Festival, but it seems that if we can convene a LegCo session before 4th of November, then it wouldn't be a problem. Then, looking forward, we just need to follow up, and it seems that the Wine and Dine Festival does not need to be. It does not need further consideration. I agree with Mr. Lamkaki. On 24th of November, I see they don't have a star or an asterisk attached to it. In paragraph 11, the ones with an asterisk involve the use of the promenade. So you need to answer us whether these events are related to what we're dealing with. And the only event that is affected by, that affects the promenade is the event between 1st and 2nd of December. The 1st of December event requires a lot of preparatory work. And if you're referring to what will be affected, as a matter of fact, under the LCSD framework, there's a difference between the West Kowloon framework. I understand Mr. Zhong Shugan's concern. There's a lot of administrative work that can be expedited, but what's the difference? Ultimately, some contractual arrangements, they are now a licensee, and the whole area be shut down or to the public, and whether there's also arrangements on the income distribution. So LCSD would have less flexibility than West Kowloon. Even though the event is in December, there's a lot of advertising, local artists and overseas artists who will be affected. There's a lot of preparatory work, and they also need to negotiate the contracts. Of course, we don't have a view, but the preparatory work has to be launched, and if we need to comply with LCSD rules, for example, their ticketing, they require a 10% commission. The West Kowloon has flexibility. They want to promote culture, so they don't necessarily take the 10%. So a scale and so on might be impacted. And Mr. Zhong Shugan, I'm aware that we don't have a full house, but before you speak, you do need to raise your hand. Perhaps Mr. Lynch could also respond on the regulatory vacuum. We'll look at it in more detail and respond more clearly. We don't have a vacuum because a lot of short-term arrangements, there is a set of regulations, even though there aren't any bylaws in place. They can regulate the public space. So when they exercise the rights of the tenants, there are all kinds of laws that regulate. We can also seek the assistance of the police. You have still avoided our concern. The concern, we're not saying whether you're not able to regulate the premises. We're concerned that you are now substituting a legal framework with an administrative framework. You have not made it clear, and that's why we're still pressing you for answers. Mr. Lynch?
I think it needs to be remembered that we've been having discussions with LegCo for over a year about short-term tenancy and use of the site for a range of artistic activities that would take place. And we've discussed it a number of times. We had an intensive briefing with the subcommittee just before the LegCo rose about those short-term activities. We have been engaged in contractual conversations since last year with the affected parties, Wine and Dine, Clock and Flap, and the range of other organisations on the basis of good faith. The first that these issues were raised from our point of view were well after I have signed the contracts between West Kowloon and the affected parties. So I think there is an issue of good faith that is important in terms of where we sit. If you repeal the arrangements, and clearly I think it needs to be understood that the difference between last year's arrangements for Wine and Dine, which were done with the LCSD because it was primarily an activity that had taken place under a set of rules and under a set of legal agreements, only impacted on the promenade site. When we negotiated for the use of the site this year, which you can see is all set up and ready to go this week, we extended the use of the Wine and Dine Festival over part of the STT and over the promenade site. I'm happy to provide you with maps of the individual activities. The Clock and Flap uses part of the promenade, but the major part of the site is part of the STT site, and the Renaissance, the Free Space Festival, uses a small part of the promenade and a large part of the STT site. So I guess the concerns I have, if the idea of repealing and saying that we have no rights over the promenade, it would put us immediately in contravention of the licences I have issued under my signature to the affected parties, and clearly the issues that have been raised by Ms Tai mean that it wouldn't say you could exclude Wine and Dine Festival from it or Clock and Flap, because they both have entered into contractual undertakings in regard to ticketing, administrative arrangements and significant financial implications for both of them, which I guess ultimately would become back as my problem for having signed contracts in terms of going forward, and ultimately will then create a whole chain of complicated legal issues, will have significant impact on the individual entities with potential commercial downside for the individual entities, including the possibility for West Kowloon, but it would also have significant impacts on the public in that, the public have, involved themselves in these activities on the basis of good faith that West Kowloon is the body carrying responsibility for these activities going forward. And I think we've done that in full and utter recognition of LegCo's involvement in it. It's unfortunate because of the circumstances that have existed, in terms of the period from July, that we are now having this conversation 3 days before the first of the events takes place on the site, and 3 weeks before the second event, which has been on sale for over a month. That's my real concern in terms of going forward. I'm quite happy to find a way to address some of the other concerns of members and of LegCo in terms of trying to address the future issue or the issues that fundamentally cause concern in the chamber, but it does appear to me that the significant practical issues are really quite important.
鍾樹根議員，你重複你頭先個問題。
Mr. Zhong Shugan, can you repeat your question? I don't have a question. I understand. Mr. Leung. Well, I've heard Mr. Lynch's response. It's very reasonable. So I'd like to ask the legal counsel. This negative vetting will lead to certain outcomes. That is, after Gazette, according to the new legal scenario, some issues have occurred. But under the negative vetting, the legal effect of the Gazette action will be repealed. So the activities or the events that occurred in the interim, I assume what Mr. Lynch said is accurate. Then in the interim, the LCSD will not be running the promenade. Then under this legal basis, they have signed some legally binding documents. Then even in the LegCo session in November, we will try to repeal the effects of the Gazette till on 6th of July. Then it shouldn't impact the contracts he signed during this interim period. I don't think there should be an impact. Mr. Leung's question on the interpretation of clauses in 34(2), it states that if the subsidiary legislation, if this subsidiary legislation, if there is a resolution to change this and it has been endorsed, then this subsidiary legislation is considered to be amended as, from the date of amendment in the Gazette. But the legal there's no impact on the legal contracts that were signed in the interim. I've heard Ms. Dai and Mr. Lynch understands our concerns. These are important concerns. But since the legal counsel has reminded us, Cap 1 has made it clear, then the West Kowloon Authority, regarding who manages the promenade, has assumed that the Gazette date is effective as of 6th of July. Then the contract signed afterwards should not be affected. So it does not mean that you need to expedite approval of permits and so on. And since we've made ourselves so clear, then you shouldn't sign any more contracts.
大小姐。
I think the problem can be dealt with. Ms. Tai, you agree? I just want to add several points. First, I thank Mr. Leung for raising this point. But apart from the bit concerning the WKCDA, whether we should speed it up, we still have something we have to deal with. If it is a pleasure ground, again, then the LCSD still has requirements which they have to comply with, and we have to find out what kind of follow-up work we need to do. And Mr. Wu suggests the arrangement, something like the Chile nunnery. And can we just use the regulation of the LCSD in the interim? We'll go back to look into that. The Chile nunnery is of a different category. The WKCD is a statutory body, and it has its own law. If it is a bylaw vis-à-vis an administrative rule, there is the major difference is on law enforcement. The WKCDA cannot enforce the law on behalf of the the WKCD cannot enforce the law on behalf of the LCSD. We think that if we use the LCSD regulation and let the WKCDA manage the place, that is not feasible. Now, you say that this time we raised the issue of the construction works. That is because we want to explain to you the whole picture. Now, if you put the promenade back into the list of pleasure grounds, and if the WKCDA wants to conduct any works, then you have to consider that this is a big piece of land, not a small corner of the Victoria Park. It is about the whole promenade. Within a short period of time, you will have to find a way to delete that promenade. If you don't delete that promenade from the list, then the activity to be conducted by the WKCDA on the promenade will be very different from what belongs to a pleasure ground. And this will have a very important bearing on the works of the WKCD. We really need to take over the place, they really need to take over the place, conduct site investigation, and then proceed with works in order to open the park in 2014. The issue didn't appear last year, as said by Mr. Lynch. The WKCDA has yet to get the land. Let's assume that at the Coconut Flat, let's not talk about the wine and dine. Then the event will be the event will take place on two pieces of land under two different rules. One may be one with a left foot on one place and a right foot on the other place, will be governed by two different sets of rules. The WKCD has got the short-term tenancy by then, and it will be and the site will be regulated by the house rules rather than the regulation. Now, concerning the point made by Ms. Tai, the right foot and left foot, according to our legal advisor, according to Cap 1, I don't know how the contract is worded. Well, I don't want to read it. Now, if it is managed by the WKCD House rules according to the contract, and it will be managed by the WKCD House rules. These activities, while being conducted, will not have this problem of left foot and right foot. When will it become a work site? That's my concern. If next week it will become a work site, then it's useless for us to discuss the matter. You will not do anything meaningless through a legislative process. When will it become a work site? Well, I'll ask the WKCDA representative to answer the question. In the beginning of next year, the end of this year and early next year, we'll have to close part of the area to do site investigation, and then probably at the beginning of next year, a major part will have to be closed because the park will have to be completed by 2014. The WKCDA colleague may add. Mr. Lynch or Dr. Chen?
And then Dr. Chan can... clearly what we're looking at is we're in the final stages of granting, making the decision on the design of the park, how that's going to be done. We're in the first stages of the tree nursery, which goes on the site, partly on the promenade site, partly on the STT site, and then the major process going forward is that none of the site, because of the complications of the railway and all sorts of other things that are happening on that site, has undergone site investigation. And to be able to, and recognising that there's two railways, a harbour tunnel, clearly the idea of meeting the demands that we have publicly stated of delivering the park by 2014, there will be immediate work taking place from the end of this year on site of an investigation to be able to realise what happens by 2014. Dr. Chan may wish to make some supplementary comment.
Hi, Dr. Chan.
Well, I think I have nothing more to add. Mr. Lynch has already said what I want to say. Mr. Chung, I want to ask the WKCDA whether it will consider make a set of bylaws in the interim to deal with the vacuum. And if so, can they proceed as soon as possible so that we won't need to deal with the mess? What is said by Mr. Leung is just for the interim. If you have 5 more activities coming, then are you going to delist the place again and do away with the regulation? I think you better consider having a set of bylaws to deal with the interim. Ms. Tai, now you say that there will be bylaws by 2013. Well, indeed, we are considering by 2013 we'll have the bylaw, and the bylaw early next year or middle next year. We can discuss that. We can speed up the process.
Yes.
If it recognises the the concerns of the members of the committee and the various other complicated legal issues. So we're happy to expedite that, bearing in mind it is now the 29th of October and we had intended to do it in 2013. We'll look at whatever we need to do to expedite that.
Mr. Chung, I know that you will do it in 2013. The problem is this. You will have all these activities. Will you do something in the interim to deal with the vacuum because the vacuum is too big? Ms. Tai. Now, in fact, we are working on it. We want to shorten that period of time. We will speed that up. We will speed up the process, and the bylaw will be comprehensive. If we just copy the regulation of the LCSD, you may cast doubts on it. You may want some improvement. Now, we are designing the park, but if we are to make a set of bylaws for the place that will soon be closed, would that be a waste of resources? Shouldn't we use the resources to draw up a bylaw which will be good for the new park? And in the interim, we will step up the management. Ms. Ellen Leong. Now, after I've heard Ms. Tai and Mr. Lynch, my inclination is that we don't need to repeal the order gazetted on the 6th of July. But I want to reiterate this. With regard to this $26 billion project, we are very keen on that. It is not a STT. It is a place of the cultural WKCD. The administration lacks the sensitivity towards the issue. According to the information given to us, we were not informed of the administrative rules. And only at the meeting when we asked our questions, Mr. Lynch came up with those administrative rules. And that was good. In fact, it shows that the administration and the WKCDA are not sensitive towards the concerns of this council. And I hope that in the future, when they work on this flagship project, which is very important to Hong Kong, they should be more sensitive. This is not a STT, not as simple as a STT. Now, they are going to close the place, and everything on the list will be the activities that will be organized and no more. Then my inclination is to accept that. Well, let me sum up what we have discussed. Members asked our legal advisor if we repeal this order, will that affect the activities listed in the paper? The answer is no, because the legal documents signed there and then remain valid. And the authority and the administration have told us when they will close the site. You've heard that. And in 2013, the administration will bring a set of bylaws before us. We'll ask whether it will be January, February, or December, or the 13th month of 2013, which means 2014. We really don't know. The administration has not paid enough attention towards the legislative requirement. It resorts to administrative expedience and has not consulted this council, though we have a concerned group on WKCDA, but the discussion was on land use, on the organizing of activities, but not the amendment of legislation. The administration has ignored the importance of this. If you look at the district council, they are not responsible for legislation. The agreement is okay for the district council to agree on that, but for us, we are very concerned about the procedure, the legislative procedure. Mr. James Toh, do you want to follow up on anything? I agree with Mr. Alan Leung. They are wrong in principle. Now, there are 2 more months to go, and then everything will be hoarded up, then it will be meaningless. Well, not December. In fact, it is until the end of until June. But part of the works will start. If need be, you can ask WKCDA and also the HAB to seek further elucidation.
So for the coming 8 months, if we repeal this bylaw, then should we leave matters as it is. Well, on the last occasion, we had discussed the regulations. Do they feel that that can be skipped? That is the administrative rules. We haven't reached that part yet. I think we've looked at that, we've scrutinized it. They're very similar. It's just they're using simpler wording. Well, I think there should be further discussion in the West Kowloon Committee. Well, we need to tell the West Kowloon Authority this is an administrative rule, even though it's a statutory body's rules. I would like to ask, if you were to make amendments, what rules will you be applying? Because these rules will be substitute the bylaws, but you need to tell us if you were to amend the rules. Will you just do it behind closed doors, or you don't need to respond to us? The West Kowloon Authority can do it on its own. I think in our subcommittee, LegCo is very concerned about West Kowloon. So can we come to a consensus that in the future, when the West Kowloon Authority amends these rules, they need to seek the Legislative Council? They should work on the same page. Just like in the last legislative term, we had set up a West Kowloon Concern Committee. It's been convened. We haven't convened this legislative year. We haven't convened this year. So I feel we need a mechanism. We need to state in advance when the West Kowloon amends these rules. They might amend because we've now allowed them to repeal the LCSD regulations and bylaws. Well, even though we haven't set up this West Kowloon subcommittee, I think the West Kowloon, they are still using the LCSD regulations and bylaws. If they were to make amendments, I think they need to meet in the Home Affairs panel. So before they will have to report in LegCo. They might seek to not make any changes. Well, I'd also like to consult with members. The DOJ and Policy Bureau, they have not drafted regulations and moved directly to administrative measures. We feel that is deplorable. So here I need to consult the Secretary. We are being asked to apply negative vetting. But if members feel that on the Legislative Council, 7th of November, you want to speak and have it on record, that is our stance on this issue. Well, regarding the bylaws and regulations, they should prepare an agenda item. The chairman of the subcommittee can speak, and other subcommittee members will also have an opportunity to speak on 7th of November. Are you referring to the House Committee or the Council meeting on the 7th of November? The chairman can allow chairman of the subcommittee to speak about the reports and the conclusions of the subcommittee. So members and chairman of the subcommittee can speak in the council meeting. It's the House Committee or the council session? Legislators and the chairman will have an opportunity to speak. We're not making any amendment or repealing, so there is no bill to raise. There is an opportunity to speak. Chairman is correct, because we are engaged in negative vetting. If we were to repeal the law, then we need to vote on it and repeal the law. But it seems that nobody has asked to repeal it. If there's no amendment, no repealing, then it doesn't have to be submitted to the council session. Well, according to Rules of Procedures 38 FA, the House Committee can the members can speak during the House Committee regarding matters raised during the subcommittee. Well, I think members want to speak regarding the repealing of this subsidiary legislation. Just now, the Secretary had read out the rules of procedure, and I think the consensus is we regret the development of deploying administrative rules to regulate the site, and we are not making any amendments or repealing the law, but I will speak on behalf of the Subcommittee on Public Health and Municipal Services, and I'll ask for permission for you to speak in the council session on 7th of November regarding the scrutiny of this report. And therefore, members can speak on record during the council session. I agree with the chairman's decision. Most importantly, members will speak. I'll also suggest that the paper has not responded, the Secretary of Justice has not responded directly to us regarding this development. So could you authorize the chairman to have the Secretary write to the Secretary of Justice on his view? I'm also unclear on were there similar situations where a statutory body on its own plot of land not apply the bylaws and regulations and rather rely on administrative rules? So could the Secretary help us? I recall the hospital authority might have a similar situation. Well, if statutory bodies, they rent a piece of land as a warehouse to store equipment and machinery, but this is different. They're hosting activities, and it gives the impression that these are events hosted by West Kowloon. The mega events. It's not as if I leased a place, a site. Well, the contractor might already deal with that, but we do expect the West Kowloon to manage these sites. Well, I think I've made a summary. Is there anything else you need to add to the summary? If not, then our scrutiny work is complete. But we make a formal request that the West Kowloon, if they make any amendments to the rules, they have to come back to the subcommittee. Why do we need to speak at the council session on records? Otherwise, you let them off the hook and you will be giving them a free hand. So when they respond in Legislative Council, you have to bear in mind this pledge that when the West Kowloon, if they were to amend the rules, they have to consult the LegCo. Mr. Wu Ji-wai. Does that mean we have accepted this temporary management? I just want to mention there are some rules that are even more stringent than LCSD. For example, number 17, they cannot fly kites, and there's also restrictions on vehicular craft. If you want to do a comparison, we still have some 15 minutes. I just want to highlight the vehicles, rollerblades, and skateboards are included as vehicles. So if they're going to be lax, then it shouldn't be more stringent than the original LCSD rules. Flying of kites and model airplanes and balloons under LCSD, the director made this prohibition, but according to the temporary rules, no kites, model aircraft, or balloons or other devices are allowed in the airspace. Well, unless there's a special notice, it should not be more stringent than LCSD. Well, if they can explain, they should do so now.
Madam Chair, clearly, I think I mentioned in our first session that in regard to your point 12, in regard to kites, model aircraft, balloons, one of the events, the major public events we're undertaking is an event called Inflation, which is done by M+, of large blow-up activity. So we would have to amend point 12 in it to allow that event to go ahead, and I'm very happy to look at that. Clearly, in regard to vehicles, as you understand, with the whole of the site, there will be, except for the disabled or for anyone in a wheelchair or requiring accessibility to the site, that we are trying to establish the idea that that remove the idea of it being a car park, or that it's open to public intersections. So we'd be looking at those issues. I'd try and draw distinctions between vehicles and skateboards, and I guess in regard to the point which Madam Chair has discussed with me a number of times before, and a number of public pronouncements that I've made, walk, run, stand, sit or lie upon the grass is clearly subject to some further amendment once we're going forward, because I've made it quite clear that we'd be looking at a less restrictive set of rules around the occupation of the park once it's finally established.
梁家傑議員。
係啦，我諗為咗清楚記錄起見咧，我諗
Mr. Langkakit, in order to clarify, I think we need to record what Mr. Wu Jiwai said. Even though we've completed the scrutiny work, we do not want to repeal the Gazette notice, but that does not mean we have agreed with the set of administrative rules. Second, could the administration, including Mr. Lynch, also pledge that after we reconvene the subcommittee on West Kowloon, that we can have further discussions? Any follow-up, Mr. Wu Jiwai? Well, I think they will make amendments, and it has to be more relaxed than the LCSD rules. Mr. James Toh, in paragraph 11, the large events. For example, after 16th of December, let's say 17th of December, but before the next event, does that mean the public, it's open to the public and the administrative rules will be applied? Well, if you are more relaxed than the LCSD rules, then it will give people the impression that it's now more relaxed. Otherwise, there is a short-term tenancy agreement with the West Kowloon, and the rules are more stringent. And you can't fly kites and so on, and then that will lead to a lot of confusion. So the West Kowloon Authority needs to understand it has to be more relaxed during times where there are no mega events. I'm not going to argue over the details. Otherwise, you're putting us in a very difficult situation. That's why on 7th of November you need to speak on record, and the Secretary needs to respond. Any change to rules have to be submitted to the relevant panel or the West Kowloon Task Force. Okay, thank you. Thank you, officials.